You're listening to Autumn on the Air, the weekly podcast that brings you conversations about the impact of research commercialization and the people who make it happen. Join us for interviews with patent and licensing professionals, innovators, entrepreneurs, and tech transfer leaders on the issues and trends that matter most. Keep listening for an inside track on the people, IP policies, and politics changing our world.
Welcome to Autumn on the Air. Today we're diving into the legislative and legal developments in Washington, D.C. and elsewhere that are crucial for tech transfer professionals. Joining us for this discussion is Jeffrey Depp, a registered patent attorney and intellectual property and innovation policy professional. Jeff has extensive experience in university tech transfer, the pharmaceutical industry, law, and the federal courts. He is currently a PhD candidate at the University of Pittsburgh, focusing on U.S. innovation from an Austrian economics perspective. Jeff also consults on biopharmaceutical innovation for the Center for Strategic and International Studies and has been active in policy analysis and advocacy through various professional organizations, including Autumn, where he is currently a member and the former chair of the Public Policy Legal Task Force. Welcome, Jeff. I'm really excited to have you on the podcast today.
Thank you, Lisa. I'm thrilled to be here.
Yeah, we have a lot to talk about today. And I thought to kick things off, Jeff, that maybe you could tell us a little bit about your background and your current role in innovation and IP policy.
Absolutely. I wear a number of hats here in DC, work with a number of different organizations trying to, promote the progress of science and the useful arts through technology and technology commercialization. I've been blessed with a great deal of both sort of real world experience coupled with lots of good formal training. I spent many years in the pharmaceutical industry. I spent many years doing university technology transfer. I've worked in the court system, so I've seen it on the ground and on the front lines about how the sort of process works, how technology moves forward. And I've seen the problems that we are currently confronting, and again, I've coupled that with some great training in hard science, chemical and biomedical engineering, business. I have an MBA. I'm a registered patent attorney, and I'm currently working on a PhD dissertation focused on the nature and causes of American innovation from an Austrian economics perspective. So I'm also studying the policy aspects of this. So I try to combine all of that in ways that I can be impactful in trying to drive the narrative and make create the policy solutions that I think are necessary in order to promote technology advancement, technology transfer, technology commercialization, that kind of thing.
Well, it sounds like you're the perfect person to talk about all of these different issues that we're going to talk about today, Jeff. So I'm super excited. So let me follow that up and ask you why it's so crucial for tech transfer professionals to stay updated on the legislative activities happening there in DC. And what impact can these policies have on their work?
Well, yeah, I think it's really important. And it's a tough sell. It's just one more thing that technology transfer professionals are being asked to do. We all know the tech transfer offices are notoriously understaffed and underpaid. And then they work really hard trying to move forward the great technologies that come to them. And there's never enough time or never enough people to handle them all. And so it becomes, frustrating when, we have sort of things in Washington working against them. When I was in tech transfer, I always thought, we have the smartest scientists. We have the most incredible facilities. We outfitted them with the best equipment, and we work hard to get them the resources they need to do their work. And yet, and when it finally comes to fruition and we're reviewing an invention disclosure that looks great and we think maybe has some great potential and we start to move it forward and we get interest from a partner, you're lucky to get an interest from a single partner, but when you get one think, wow, this is great. We're finally getting somewhere. We're going to accomplish our goal and achieve our mission. But I was always concerned that with, sort of the stroke of a pen or the click of a mouse from somebody in Washington, all that just goes right out the window. So I coined this phrase that bad policy can devour even the very best science. And so, it was at that point that I really felt that, I always had an interest in this, of course, but I really wanted to try to apply it, in the tech transfer profession and in the setting of what we do to try to minimize that, to try to say that doesn't happen. And then so I got involved with Autumn's Public Policy Advisory Committee and the Public Policy Legal Task Force as a way to try to do my part so that again didn't happen. That when these great technologies, these great inventions are made, we're able to move them forward, and we're not sort of fighting we're not fighting the people in Washington. When we have to fight so hard, just, as it is in terms of, getting the money and de-risking the technologies and further developing and all the pitfalls and problems and things that you run into when you try to do that. Again, it's hard enough, and we just don't need, folks in Washington making it any more difficult.
No, absolutely. And I love the phrase that you coined, and it's so true. And, let's start digging into some of those. This year, there have been several comment periods for proposed administrative agency regulations. Can you tell us the status of those and what's likely to happen with them?
Right. This year, when we try to follow this, we try to follow it in an organized fashion, because there's so much going on here. So we try to sort of keep our eye on three buckets, right? The administrative law side of it, what's going on in Congress with legislation, and of course, what the courts are doing. And to your point about the administrative side of the coin, if you will, this year has been extremely active. It's the most active year that I've seen since I've been following technology commercialization policy or innovation policy, if you will, with probably 9 or so comments being requested from various agencies, so far this year, which again is just, historically speaking, is unheard of. And we've all been, burning the candle at both ends, trying to respond to all of these requests for comments. And it started back again early in the year. There was a request about, and all of these are very relevant to what we do as technology transfer professionals, about the role of artificial intelligence in the invention process and who is an inventor. The USPTO put out some guidance about how to determine whether, who is the inventor and whether there is proper human inventorship. As we know, the courts have looked at this and said that the inventor must be a human being. And so, the Patent Office, followed on with that and issued some guidance to the examiners about, how they make that determination as to whether or not there is sufficient human inventorship activity with a particular invention such that it could be patentable. And the guidance, and so they put out that guidance to the examiners, and they requested that the public provide comments on that. And Autumn was, right in there providing comments on that. We generally supported the guidance. We thought that the Patent Office did a good job of sort of making sure that it was able to find the human involvement, because we were concerned that there would be too many instances where, you just wouldn't find a human inventor, and therefore it wouldn't be patentable, and we'd lose out on some really great breakthrough technologies because AI was involved. But again, we were pleased and we were generally supportive of the USPTO's approach to be very broad in terms of their ability to find that human inventor, such that you could clear that first hurdle at least of having enough human inventorship to be patentable. So that was the one. That was an early one that we commented on. There was one from the Patent Office, right on point with what technology transfer professionals do, about how the Patent Office was asking how it could promote moving more innovation into the marketplace. I mean, how could it support technology transfer? So we provided some comments on that, giving them some ideas about what the Patent Office could do to help us, which again was great. We're always happy to have that. The Patent Office put out a a notice of proposed rulemaking regarding some fee increases. I know we were less thrilled about this one, as you can imagine.
Yeah, that's not pretty.
And there was some significant increases in various patent fees proposed for fiscal 2025, and a lot of them had to do with the continuation applications and some significant increases for the continuations, and particularly as the later in the sort of along the way that those continuation applications were filed, the fee increases went up significantly from that earliest priority date. So, it was clearly designed to discourage applicants from filing continuation applications long after the priority date. And again, this is concerning. As technology transfer professionals, we know we're dealing with early stage technologies when we have to file our patent applications, and we don't know what the end product is really going to look like at that point. So in order to support our partners, we are often filing lots of continuation applications so that we can sort of marry up the patent with the end product, so to make sure that it's properly protected. And you use those continuations to tweak the claims in order to keep that alignment, to keep that marrying up in place. And so, this could be of significant concern to the technology transfer and university-based inventing with this. So there was some significant concern over that. A number of groups filed comments on that, and we're hopeful that the Patent Office will, relent a little bit. But we're not optimistic, to be honest with you, because obviously, the Patent Office, it's an expensive operation, and they need to have sufficient resources to do their work. So. We're watching that one carefully. There was another one related to the director review of PTAB decisions. We didn't get too involved in that one, because the volume of these requests, we had to pick and choose a little bit. So we didn't, get involved with that. But that one was just sort of codifying some of the changes that came out of the Arthrex decision that required the director to have oversight of PTAB decisions and making sure that, because again, the PTAB judges were deemed to be, by the Supreme Court in the Arthrex case, officers of the United States. And so, they needed to have sufficient, who were not confirmed by the Senate. So they did need to have proper oversight from the director. So that was what that was focused on. There was a comment requested by the Patent Office regarding Patent Trial and Appeal Board, PTAB practices, regarding the inter partes review process. And Autumn was eager to file comments there because the Patent Trial and Appeal Board inter partes review is over the years since its inception from the America Invents Act, has been very much skewed in favor of the challenger, in other words, against the patent owner. And this has made it difficult for universities, for tech transfer offices, and it's made it more difficult, let's say, to find partners for its technologies, to find licensing partners, because the partners were, in addition to everything else that they have to be concerned about, now had to worry about whether at the time when they most needed their patent, on when they brought their product to market, that it would be, not there for them. It can be challenged and invalidated at the Patent Trial and Appeal Board, the tribunal within the Patent Office. And it has been, again, a growing problem. And Autumn filed comments in order to try to encourage the Patent Office to lessen that effect, or to make it more balanced, such that the outcome is more favorable for patent owners, because this will make it easier to find partners to license our technologies. And there were a couple of issues around things like discretionary denial, which gave the PTAB judges an ability to not institute the inter partes review. And we're trying to encourage the Patent Office to make that easier, because less challenges means less invalidations, and that's a good thing for the licensing process. There were issues about repeated challenges, whether they occurred one after another or in parallel. Again, Autumn urged the Patent Office to curtail that process because, again, it was making it more difficult for our partners, for our licensees, because they were concerned about what might happen to their patent under constant threat of invalidation. So Autumn filed comments on that particular request. And there was another request for comments about a proposed change to terminal disclaimer practice. The USPTO is considering a change. Under this rule, a terminal disclaimer must include an agreement that the patent will be unenforceable if it is tied directly or indirectly to another patent that has any claim invalidated or canceled based on prior art, anticipation or obviousness. And this new enforceability requirement would be in addition to the existing provisions that require a terminal disclaimer to match the expiration date of this claimed patent to the reference patent and promised enforcement only during common ownership. So this is a major change, and it would add a new condition, and it would really make it sort of much easier, again, to invalidate patents and a number of patents rather than having to challenge each patent individually, which is how you'd have to do it under current practice. By focusing on any patents that are tied together, the proposed rule allows a challenger to pick the weakest patent or the weakest claim within the weakest patent, challenge that, and then all the patents tied together through the terminal disclaimer would also fall. So it's very, very concerning that it, again, puts more, sort of tilts the balance of power in favor of patent challengers or alleged infringers, which is, again, of great concern to our licensees because, they are the ones who are sort of, paying the price for this infringement. So, Autumn was commenting on that, and basically asking the office, describing, how problematic that would be for universities and tech transfer offices, and asking them to withdraw the proposed rule. There was one recently with respect to back into the AI context. It was looking at the impact of artificial intelligence on prior art and what constitutes a person having ordinary skill in the art. Again, Autumn was active and eager to comment on that particular issue. And, basically, our approach was that, again, back to the issue of, AI and inventorship, that, the human being is paramount. And, because the concern was that, with respect to AI and prior art, that the AI has the potential to generate in the world of generative AI has the potential to generate tons of prior art that could be novelty killing or creating more obviousness rejections. And that people would actually try to do this intentionally to eliminate our ability to get patents on potentially breakthrough in technologies. So, Autumn took the position that we were urging the Patent Office to exclude that kind of those kinds of quote unquote references or disclosures from prior art, so that they wouldn't end up, making a lot of really good, potentially breakthrough technologies unpatentable in this way. So we really urged them to focus on the human aspect of this and making sure that there was, before a reference could become prior art, that there was sufficient human involvement. And the same thing with respect to what constitutes a person having ordinary skill of the art. We urge the fact that, hey, human beings are really, again, the central core here, and human beings do not have unlimited ability, to process information. And so we can't let, the AI and its ability to generate new knowledge create these superhuman facetas, which would then, make claims and patents easier to declare that they were obvious, because this person having ordinary skill in the art now is so much smarter than they otherwise would be, without the benefit of AI. And so we really urged the Patent Office, again, to make sure that we were not, again, denying our ability to get patents on these breakthrough technologies as a result of all the good things that AI can do. We just want to make sure that, again, we're using it for a productive purpose and not something that's going to, again, hold back the development of new technologies and their commercialization. There was a request from the NIH. They were talking put out some draft guidelines for their intramural research technologies. In other words, things that they produce as a research organization and the technologies that they own. They were considering requiring anybody who wants to license those technologies to put in place an access plan for the end products. To make sure that, lower income countries, for example, would be able to get access to these technologies. And while that sounded good, we were concerned that might, again, further disrupt or further throw sand in the gears of the technology commercialization products, because when you're so early in the process, it's really difficult to know what the end product is going to be, what it might cost, who it will benefit. So trying to have to put together an access plan for something that is so far into the future is really going to make people sort of, we think, shy away from trying to gain access to those technologies, to use them, and further develop them. And of course, the biggest concern was that while that was limited, at least for now, to the intramural research, it was easy to envision a scenario where that would quickly jump to their extramural research program. In other words, where the NIH is acting as a funding agency, which is the far bigger sort of piece of what they do, funding so much work at all the universities across the country. We got concerned that if that requirement was placed onto those technologies, then again, it would further impede our ability to move those technologies, to partner them, and to move them forward. So again, we raised some caution about that one. And I think the last one that's coming up is about the experimental use exception. That one has been recently introduced, and we are looking at that to whether that should be codified or left as it currently is, sort of a judge-made or a common law-based doctrine, if you will. So that again is a quick trip through a number of really meaty and substantive comment requests that the folks who rely on strong patent rights were engaged in, and when we're commenting upon, and Autumn was a very active player in all of that, and we'll look forward to see what the agencies do with our comments as well as the comments of many other groups.
Well, thank you for both your work and the work of the Public Policy Legal Task Force at Autumn. It sounds like you guys haven't had a breath, and we're only in August at the moment. So there's still time left for more comments, and I'm sure they're probably coming, given the way the Patent Office in particular has been going this year. So let's leave the administrative side for a little bit here, Jeff, and talk about what's been going on in the courts. And I thought we'd start right at the top and talk about some recent Supreme Court decisions. I think everyone has heard about the Loper case and overruling the Chevron deference, and there's also the SEC versus Jarkesy. How do you think these rulings affect the tech transfer field?
Yeah. These were important decisions. Obviously, they've gotten a lot of attention, and I, it's going to be interesting to see how they impact, technology transfer, because there were not directly related to, technology transfer was not implicated in the case directly, and neither was intellectual property. But, these are important decisions that affect some foundational, aspects of American jurisprudence. And, people are wondering, how will it impact what we do? And I think, the Jarkesy case is interesting because while, again, as I said, it is not directly on point for intellectual property, it actually, is referenced, an important case that did directly implicate intellectual property issues. And that was the oil states case from 2018, and where that was the constitutional challenge to the PTAB and the inter partes review process that was instituted by the America Invents Act that we talked about earlier during our administrative law review. And, in oil states, where the court upheld the Patent Trial and Appeal Board and the inter partes review process was because it decided in that case that patent rights were what they called public rights as opposed to private rights, which allowed for the administrative tribunals. It gave them the ability to adjudicate those cases. The argument was by the challengers to the law that brought the case was that the PTAB inter partes review, having the USPTO be the determiner, being the arbiter of the validity of a patent, is improper, that it must be done via an Article 3, by a federal district or appellate court, not via an administrative tribunal within, the executive branch. But again, the court disregarded that argument and said, no, because patent rights are public rights, that procedure stands. And in Jarkesy, it went the other way, basically. The person, the individual challenging the ruling of the SEC in this case, another administrative agency, he did have a right to a jury trial. And the distinction fell on the fact that the fines that were at issue in that case were considered to be in the private rights sphere. So the rights implicated, by in the case were again private rights, not public rights. So that the individual, so he found in favor of the challenger, and that those actions of the administrative tribunal were improper, and he needed to be able to have his Seventh Amendment right to a jury trial. So in those opinions in that case, they, can sort of revisited the oil states decision and talked about, again, the difference between public rights and private rights. And, so it kind of, in some ways, validated or ratified that decision of oil states where patent rights, again, are considered public rights. And again, that to many of us who work in this field is difficult to swallow. We, most of us look at the constitutional provisions that the patent clause and the exclusive rights and the history behind it, and even some of the statutory provisions that really hint and certainly strongly indicate that patent rights really are private rights. This case again is interesting to be aware of, in that it sort of continues that this private rights, public rights doctrine is continuing, particularly where patent rights are concerned, that's unfortunate for us. So there was an opportunity, I think, in the Jarkesy case, maybe to undermine that a bit, but that didn't happen. So we'll see what happens going forward. But I think most folks who have looked at that case kind of see that not much is going to change there, unfortunately. And the Loper Bright case, again, is an interesting case. Obviously, it's gotten a lot of attention. Longstanding doctrine of sort of deference to the interpretation of the administrative agency that the courts had no choice but to accept has been overruled. But in terms of our space, in terms of the intellectual property space, the impact is probably not as great, because historically the federal circuit, our appellate court, if you will, the IP appellate court, didn't really provide much deference to the USPTO, either to the examining court or the PTAB, such that it doesn't appear like much will change there, because the deference was never there in the first place. So again, we're going to have to watch going forward to see, if there is, again, and when there might be evidence of deference to the PTO on certain matters, litigants may be able to make an argument based on the Chevron decision that deference was improper, and maybe get a chance, to argue that point and maybe change the outcome in their favor. But for the most part, right now, given the fact that there wasn't much deference to begin with, it really remains to be seen whether the impact of the Chevron case will have much effect in the work that we do with respect to intellectual property and particularly patents.
So, Jeff, before we move on and talk about some of the key cases at the federal circuit, let's just stick with the Supreme Court here for a second and talk about some of the pending cases that you think tech transfer professionals should be keeping an eye on. I know one I'm keeping my eye on is the Cellect case. You mentioned the comments with respect to terminal disclaimers, that is a very important terminal disclaimer case. And talk to us a little bit about the cases that are pending there, what effect they might have on the tech transfer industry.
Yes, I agree, Lisa. The Cellect v. Vidal case is a very important case for technology transfer professionals to be aware of and to be following as we move into the fall. The petitioner has petitioned for certiorari, and a number of amicus briefs have been filed in support of certiorari. And over the summer, the Patent Office will be filing its opposition to certiorari. And we'll see whether the court decides to take it when they return in the fall. The issue in that case is a very interesting issue at sort of the intersection of patent term adjustment and obviousness type double patenting. This case establishes binding precedent that a terminal disclaimer cuts off any extended patent term granted through PTA. And that was a bit troubling because it contrasts with prior rulings regarding the other type of patent term, lengthening patent term extension, right, which is the sort of the sister to patent term adjustment, right? Patent term adjustment, remember, is additional term granted as a result of patent office delays that we often run into as technology transfer professionals. Patent term extension is when term is adjusted for regulatory delays. So, for example, if you're a pharmaceutical company and trying to get your product FDA approved, and that and while your patent clock is ticking, but you can't market the product until you get your FDA approval, there's a provision in the code that allows the term to be extended there, so that delay doesn't cost you. As an innovative pharmaceutical company, and this case really sort of draws a distinction between the two, and the result again was that the patent term adjustment is lost as a result of filing a terminal disclaimer in order to maintain or order to avoid that dreaded obviousness type double patenting rejection, which, as you know, obviousness type double patenting is a judicially created doctrine. It prevents an inventor from obtaining a second patent for claims that are not patently distinct from the claims in a first patent, right? It's based on the language of Section 101, which talks about a patent, singular, for an invention, not two. So the obviousness question, the obviousness double patenting rejection comes about, not through sort of documents that are prior art, because they don't qualify as prior art. So this is where the judge-made doctrine came in. It didn't fit under 103. So the judges decided that, again, that they felt that because the patents and the claims were so similar that they didn't warrant separate patents. And so they came up with this doctrine, again, about double patenting, obviousness type double patenting, and the way applicants were allowed or able to deal with that was to disclaim any additional term beyond the expiration of the first patent. And again, this typically came about, years ago when we didn't have the patent term ending based on the priority date, right? When patent term was calculated from issue date, when you filed later patents and they issued later, you started your patent clock. So you had a number of different expiration dates on related patents. And that all went away in 1995, when we went to calculating patent term from the earliest effective filing date. And everything went back to there. So it was 20 years from there. So you had, largely this issue was eliminated at that point. Because again, most of the patents all tracked back to that same priority date. So they were all ending on the same date anyway. But this is where this patent term adjustment would come in on certain of those applications. If they were delayed in the office, they could get patent term adjustment, which pushed their expiration date beyond the 20 years from the filing date. So you started to see different expiration dates again. And that's where this double patenting rejection would apply. Patent applicants very easily would just say, okay, we're going to disclaim that additional term, when it came about, but was never really applied to the patent term adjustment. Patent term adjustment was always sort of added on top of that. And now this case decided, no, that was not the way it should be done, that you don't even get your patent term adjustment. You have to give that up. And so, again, so many patents are affected by this because there's such a large volume of continuation practice, in United States patents, as we talked about earlier in the terminal disclaimer rule that the Patent Office is considering. There's so many patents that are impacted by this that it becomes difficult, that there's a significant chance that patents that you will lose a lot of term as a result of this case, and the ability to not be able to maintain the patent term adjustment. And so that is, again, of great concern to patent owners, as I guess I said, so many patents are done. There are so many continuation applications pending that end up with different termination dates that it can be a problem.
Yeah, and that one in particular is very concerning because you probably saw the blog from Kathy Vidal a couple of weeks ago saying that USPTO pendency is kind of at an all-time high, that the backlog has really grown in terms of unexamined applications, and patent term adjustment is increasing. So that is a very significant effect with respect to the Cellect case.
No doubt. And again, it's going to be important to see in the fall. I think the court will probably rule to decide whether or not to take the case in one of its early conferences when it returns in the fall. So something to keep an eye on in October for sure.
For sure. And besides the Supreme Court obviously being busy, the Federal Circuit is always busy. And can you share with us your thoughts on what some of the key decisions have been? I know the LKQ Corp case was very significant for people who prosecute design patents and overruling Rosen-Durling framework for obviousness. So talk to us about that case and any other ones you think were particularly noteworthy.
Yeah, that was a really important case, and I think it really highlights a couple things that are going on at the Federal Circuit. They are really sort of overhauling obviousness law across the board, making it much more easy to find patent claims obviousness. And again, this one it impacted in design patents, and I think it's important to be aware of, because I think design patents are an underutilized resource in technology transfer. I don't think we take enough advantage of them as we can, because they're very, very effective and very powerful. But you're right. This was an en banc Federal Circuit decision, and the Federal Circuit does not go en banc very often, but they did here. And as you mentioned, they overruled the longstanding Rosen-Durling test, which basically was a very more objective test as to how you determine that a design patent claim is obviousness. There's certain rigid sort of requirements, very much like the old TSM test for utility patents, teaching, suggestion, motivation, for combining references to determine whether a utility patent claim is obvious. That was sort of not abrogated, but certainly lessened as a result of the KSR Supreme Court case back in 2007, I believe, that again made it easier to find utility patent claims obvious. Now they sort of applied that same approach here and actually used the KSR decision here to suggest, as you said, that the Rosen-Durling test is too rigid and we need to have a more flexible approach. So by overruling that and trying to sort of broaden out the applicability of KSR from utility into the design patent world, now also the same result, right? Now design patents it's going to be easier to invalidate design patents for obviousness. So on one hand, we say, yes, we should be using more design patents. We should be looking for opportunities to file design patents. Be aware now that design patents, again, are a little less robust than they used to be as a result of this case. And that is, again, that's unfortunate. But it's why it's important that we be aware of this decision.
And I think one that everybody's looking forward to hearing some more about is the University of California versus Broad Institute case regarding CRISPR technology. Do you have any sense on when we might expect that decision? And are there any other federal circuit cases that are pending that you think we should keep an eye on?
That's the big one. They had heard argument back in early May about this. The Federal Circuit heard argument back in early May, and just to refresh everyone's recollection, the University of California. This is about CRISPR patents, and it filed its patent application describing CRISPR-Cas9 complex and claiming its use in prokaryotic cells as well as eukaryotic cells. First, they actually filed their patent applications first, but in the eukaryotic context, they didn't have results. They didn't have successful results when they filed. They were more sort of had prophetic examples and sort of extensions of their work with respect to the work in prokaryotes, but they couldn't show that it worked. And the Broad did. The Broad is the institute out of Boston. There's sort of a joint venture between Harvard and MIT, and they filed an application, and they had their results in eukaryotes. So they have been in an epic battle ever since, trying to decide who actually invented its use in eukaryotes. The University of California group clearly has it in the prokaryotic cells, but so far, Broad has come out on top in terms of the eukaryotes. But it's on appeal, and that's what the discussion, that's what this case with the Federal Circuit's going to be asked to ultimately determine as who invented first, so who has the patents, for its use in eukaryotes. And again, this is important for technology transfer professionals and working with partners and licensees, because gene editing is becoming so common, and it's only going to continue to grow in terms of our ability to use this to make great health breakthroughs. So people need to know from whom they need a license. Obviously, when you're researching, you're pretty much in the clear. You can continue to work with it. But by the time you start to go commercial, you're going to want to know from whom do you need a license. And it's right now, it's probably both, everybody. But, we want to be sure. We don't want to have to take any more licenses than we need to. It's hard work and time consuming, but we need to do it. So again, the outcome of this case is going to matter. Of course, again, the whole gene editing, right? Technology is evolving, so new ways to do it are coming out all the time. So again, that's something to keep in mind too. This was the original approach, and it's become again more efficient, and there are different ways. So whether these newer technologies rely on and read on the earlier claims of the patent, again, will have to be determined. But this is sort of the first step in terms of determining, again, from the original technology, who are the owners, who are the inventors, and from whom do we need a license if we're using, that version of the gene editing in the work that we're doing. So this is an important case to keep an eye on, and we'll see when the Federal Circuit comes down with its decision. I wouldn't expect it soon. It is it's an important case, and it's a complicated case, so it's going to take some time for them to render their decision, I would think.
I would think so. And then I think they'll probably request rehearing en banc, and then it'll make its way to the Supreme Court. So it's still got a long way to go, I'm afraid. So we'll keep our eyes out for that one. And let's switch and talk a little bit about what's happening on the legislative side. Let's start talking about all the different patent bills that Congress has introduced, like the Prevail Act, the Patent Eligibility Restoration Act, the Restore Act, RALIA, and the Balancing Incentives Act. Tell us a little bit about the key points of these bills and what you think the impact might be for tech transfer.
Yeah, these patent bills are very important, and a lot of hard work is on behalf of the legislators, their staffs, and those of us in the pro-strong patent community and technology transfer. We all see the need, to sort of, for some reforms to the system. There are a number of problems with the patent system at the moment, and they fall into sort of two buckets. One I call things that make patents unreliable, and there's a problem that makes patents uncertain. And what I mean by unreliability is that, again, when patent owners, licensees, investors, startups, people who develop these technologies and bring them to market need to be able to rely on their patents. They need to be able to know that after all that time and investment and hard work, the product is ready to be introduced to the marketplace, that they don't have, the patent is there to prevent copycats from coming in and basically being able to just copy their work, bring out the same or similar product without having to do all that hard work, all that investment. And that obviously gives them the ability to undercut on price, or allows you to reap, if you come in at the same price, you're not having to recoup all that investment. So you have a significant advantage in the marketplace, and it can tend to really sort of bog down and impair our ability to develop new technologies. That's the reliability. And then there's the uncertainty of, again, what is patentable, right? When we talk about subject matter eligibility, that's what we're talking about in terms of it's just uncertain as to what we can get a patent on. Can we get a patent on a medical diagnostic? Can we get a patent on a computer implemented process? It's really hard to tell right now because of the current state of the patent system, the current state of the law. And so these bills are attempting to address that. And the bills that are attempting to address the unreliability mainly focus on, because the unreliability really comes from two sources primarily. It's this, as we've talked about, this constant threat of invalidation from an inter partes review proceeding at the PTAB, right? Anybody can challenge your patent at any time. And as we've said, the statistics, the history so far is heavily skewed against the patent owner in favor of the challenger, in order to, such that the patent owner often loses. These claims are canceled as a result of this proceeding. So again, the patent is unreliable. And then the other aspect is the fact that at present, as a result of the case called eBay versus Merck Exchange back in 2006, it's been exceedingly difficult to obtain a permanent injunction. If you're a patent owner and you sue an alleged infringer and you're victorious and you get a ruling in your favor that the accused infringer is now an adjudged infringer and penalties need to be implemented, well, one of the things that you should be able to do is get an order from the court telling that infringer he or she must stop making, using, or selling the product because it infringes your patent. That is historically the way it was. And as a result of that case, however, it became much more difficult to obtain an injunction, that stop order. And you had to rely on money damages alone. And while money damages are great, they often, they're not the deterrent that an order to stop selling or making or using the product is. And so it has, again, made patents less reliable. It has encouraged infringement. And again, these legislative proposals are aware of this and are attempting to address that. And then on the uncertainty side, again, there is legislation that is designed to eliminate the judge-made judicial exceptions to patent subject matter eligibility, again, with respect to diagnostics or computer implemented processes. We're going to eliminate that and just make them eligible as they, as per the statute. So with that background, these bills, there is a sort of, again, two approaches here being taken. One is sort of an omnibus approach that one bill that is called the RALIA bill attempts to fix all three of these issues in one bill. And then there are the other bills that you mentioned, the Prevail Act, the PARA, and the Restore Act tackle the problems individually. The Restore Act attempts to restore the ability to get an injunction. The Prevail Act is some legislation that attempts to sort of rebalance the outcomes at the PTAB, the outcomes in the inter partes review process. Again, as we've talked numerous times during this session, that it's heavily skewed in favor of the challenger. This Prevail Act attempts to implement some reforms that's going to put that more back into an even, more in favor, less in favor of the challenger, so that your outcome is not always that the patent gets canceled. So again, that will increase the reliability. And again, on the uncertainty side, this PARA, that stands for Patent Eligibility Restoration Act, again, is basically attempting to provide certainty by abrogating, by overruling expressly these judicial exceptions that say, yes, despite the statute, this type of technology is not eligible for a patent, and this type of technology is not eligible for a patent. So it attempts to correct and clarify that, we're going back to what the statute says, and such that, if it is the four statutory categories are paramount and carry the day. There are no judge-made exceptions for things like I said that we've talked about. So again, it's the compositions of matter, articles of manufacture, machines, and processes. If you're one of those four statutory classifications, you're going to be eligible. That's what the PARA bill attempts to do. And as I've said, this RALIA bill has those three components already built in. And so there are, again, different people have different ideas about how best to do that, and that's good. So that debate goes on, and hopefully the idea will be we'll sort of figure out which approach is best and try to move that forward. Now, I don't think anybody, given that we're in an election year, it's already August, I don't think anyone necessarily expects that any of these will become law in this Congress, but we're trying to build momentum for dealing with this in the subsequent Congress after the election and Congress returns in the new year, 2025. That will be in a good position to kind of keep these bills moving forward and get these fixes that we need. So again, important work being done on the legislative front to try to fix these problems related to patent unreliability and patent uncertainty.
Absolutely. Really important. And I know with respect to trying to fix Section 101, that's been something that Tom Tillis and Senator Coons have been trying to fix for a while. So we'll see what happens on that front. And, there's some other interesting bills that have been introduced, particularly by the House, that are not patent related. And the one I'm thinking about is the Countering Communist China Act. Can you tell us a little bit about that proposal and how that might affect tech transfer?
Again, that's a very interesting bill, and there's another one, that also I would want to mention that might even be a little bit more important. It's the Invent Here, Make It Here bill that was recently marked up in the Senate this week, actually. And this legislation is sponsored by Senator Baldwin of Wisconsin and vice presidential candidate and senator from Ohio, Senator Vance. And the idea of the legislation is to, as it's named, is sort of require U.S. manufacturing of technologies, of products emanating from technologies that were invented here in the United States with federal funding. And, and again, while that sounds good in theory, much like the Vidal provision requiring substantial manufacturing in the United States, there needs to be an ability, if that can't be done, that we can go elsewhere. And, and that's why the provision for a manufacturing waiver exists in the Vidal, so that if you make a good faith effort to have U.S. manufacturing and it just, for whatever reason, the capabilities don't yet exist, that you're able to go elsewhere to find it. And it's particularly important if your product happens to be intended for an overseas market. Sometimes they have their own requirements that the product be made there. So it makes it very difficult. So you need that flexibility. And the Vidal Act, despite its shortcomings in terms of the actual process of getting a manufacturing waiver, as anybody who's attempted to get one knows, at least it is there. And it recognizes that sometimes you just can't manufacture it in the United States and you need to be able to go elsewhere. Well, the Invent Here, Make It Here bill initially put very strict requirements on that. And again, the concern was, while we all support manufacturing in the United States, we're recognizing that sometimes it just can't be done. And we were just afraid that there would take us back to the pre-Vidal era, where you had a lot of great technologies were just wasting away on the shelf because they couldn't find a U.S. manufacturer. So we've been working with the senators, the sponsors, to try to, build in more flexibility. It was marked up in the Senate this week, and we think that it's better than it was, but we're still watching it. We're still being mindful that we, don't want to inject sort of an additional, or I like to say, throw more sand in the gears of technology transfer with these requirements that don't provide the flexibility or don't provide ability to get a waiver when the opportunity to make it here is just not possible. So that's an important piece of legislation that we're looking at. That was in the Senate. To your point about the countering Communist China Act, that again is important in that there's a number of bills floating around who are targeting and focused on the impact that China is having with respect to their intellectual property, documented intellectual property theft. And there are a number of bills and provisions that are attempting to minimize and prevent that. This bill is very comprehensive, has a number of provisions in it as to how to do that. And it also incorporates a number of the changes that we talked about on the patent side, and from some of the bills with respect to patent eligibility, with respect to the PTAB, with respect to injunctions. There's a number of components that are built into this very comprehensive, very large bill. So it's not sure exactly where that one's going to go because it's so comprehensive. And again, for the same reasons, it's late in the year, in an election year. We're not sure whether this will have any legs. But it's certainly something to keep an eye on because again, the issue of China is a hot button issue, and you just never know when something like that might gain some momentum and move through, and we're just being very careful to keep an eye on that. Like I said, very complex, very all-encompassing legislation.
Now, I want to ask you about something that's going on at the FTC, the Federal Trade Commission, and its move to ban non-compete agreements, which to me can have some significant ramifications. So talk about how this change might affect tech transfer offices and how they work.
Yeah, this is an important one because, in the startup world, there's just a handful of people, all right, men and women who the inventors, who move to form these startups. They are vital to the success or failure of the business, and it's usually one or two people can make or break the company. when it's just getting formed like that. And so non-competes have historically been very useful tools that investors like to know are there so that they can be sure that their key man or key woman is not going to be leaving and going to potentially start up a competitor down the street. So these are very common, very prominent in this in this setting. And earlier this year, the FTC issued a rule that basically banning all future non-compete agreements and making existing ones invalid and unenforceable, except in a very small handful of cases. So again, there have been great concern. And the minute the rule was released, the Chamber of Commerce filed suit against it. And it's already, so this rule has been sort of working its way through the court system already. And we've had 2 trial court decisions that frankly have been the opposite of one another. We had a decision on a case in Texas where the court granted a preliminary injunction blocking the implementation of the rule, found that the FTC did not have authority to issue such a rule. Most recently, a court in Philadelphia refused to issue a preliminary injunction against the rule, saying that the FTC did have authority to do that. And it's, basically the FTC that is much more active these days than it ever was under Chairman Khan. He basically is saying that under its Section 5 authority to police unfair methods of competition, that's their basis for issuing the rule. They believe that non-compete agreements they have deemed them to be unfair competition, and because it restricts people's ability to move and find work. And while that, I guess, theoretically is true, historically, these agreements have been carefully and narrowly tailored by the courts to keep them short on limited on duration and geographic area. So again, so that to balance the needs of both sides, the employee and the key people, but the investors and the company who are so reliant on the brains of one or two people, and it seemed to work well. It seemed like we had the right balance. The FTC unfortunately disagreed, issued this rule. And so it's important that we keep an eye on this, particularly as we're working with our startups to know whether or not we can institute those agreements. And if we can't, are there alternatives, or what might that do to an investor's willingness to fund a startup if they're afraid that that person could just up and walk out the door, and there would be nothing we could do to prevent them from doing that. So it's a great concern.
So Jeff, thank you for sharing all your insights with us today. It's obviously very clear that staying informed about what's happening in DC and elsewhere is vital for anybody who's involved in tech transfer. Before we wrap up the podcast here, do you have any final thoughts or advice for our listeners on how they can stay ahead of these legislative and legal changes?
Yeah, it's not easy.
No.
I mean, they deliberately make it difficult. And I think starting going back to what we talked about in the beginning, the best way I think is to sort of compartmentalize it in your mind and be able to kind of be on the lookout for things in the 3 general areas, right? Keep an eye on, what's going on in the courts. Focus on the federal circuit. Obviously, that's the most important court for technology transfer professionals because it's the IP appellate court. And of course, anything that comes out of the Supreme Court has important issues, but, pay attention to that. Look for those cases that come across your news feeds or, the things that you look at every day for, like, say, for information. That is going to help narrow it down and focus on the things that really matter. Congress, again, there are committees in both the House and Senate, subcommittees that of the Judiciary Committee in each body, in the Senate and the House. The Judiciary Committee has a subcommittee that's focused on IP. So try to focus on those subcommittees. Keep an eye out for what's going on with them because they're the ones who are driving, the legislative changes. I say the Prevail, Restore came out of the Senate Judiciary IP Subcommittee. And the RALIA and the Balancing Incentives Acts came out of the House Judiciary IP Subcommittee. So again, be on the lookout for what they're doing. That will help you sort of find the signal in amongst the noise on the legislative side. And then again, on the administrative side, again, focus on the USPTO, obviously, the biggest, the most important, they're issuing things that we need to be aware of. But the NIH also, two of the things we talked about came out of the NIH. The rest of them came out of the USPTO. And again, as we just finished talking about, unfortunately, we have to sort of keep at least a little bit of an eye on the FTC because, again, they become more active. And, obviously, we're talking about commerce. We're talking about new business startups, so the things that they are doing. And they're also involved in other things related to what the pharmaceutical companies are up to, pricing of products, so that's another agency. Unfortunately, I wish we could keep it more limited, but we have to be on the lookout for what they're doing. So try to, again, have that hierarchy of things that you want to just be paying attention to, because that's I think the best way to kind of find the things that are most relevant to our livelihoods and the work that we do on a daily basis.
Yeah, that's great advice. And thank you so much, Jeff, for all your time today and the depth and breadth of all that you've shared with us. This has been tremendously insightful.
Thank you for having me. I enjoyed it very much.
Thank you again, Jeff, for joining us today for this very insightful conversation. To our listeners, thank you for tuning in to this episode of Autumn on the Air. Stay tuned for more insights and updates in the world of tech transfer. Until next time.
Thanks for listening to Autumn on the Air with Lisa Mueller. Get social with us and share your thoughts. You can tweet us at AUTM or visit us online at autm.net. We'll be back next week on the air. Be sure to join us.